Now coming on to ayat number 282, we started on this transaction, and this the first part of this ayat 282. It deals with future payments and future consideration. That means you buy the goods today and you agree to make the payment on a future date. So this is a transaction according to Abdullah bin Abbas radhiyallahu anhu. This verse relates to Bay Salam transaction. Bay Salam transaction is that I buy something from you today on the spot, and you give me the delivery of that after a certain period of time which is agreed between us. That's a Salam transaction. Suppose I come to you and I say I want 86 rice, 1 ton, and you need to make a delivery of that on the 1st of August. So that's a transaction which you call a forward transaction. This is the only forward transaction that's allowed. And the person says, fine, for 1 ton I'm going to charge you 100,000 rupees. I pay him 100,000 now. He delivers that goods to me on 1st of August. This is what you call a Salam transaction in Islam. And this is where you're talking about that when you are dealing with one another, contracting a debt, because I've given the money, you haven't given me the product. The product you will give me on after 8 months. Then you must write it down, and there should be a scribe who must write it down with fairness. As Allah has taught him to write, then he should write. So therefore, for such transaction, it is necessary that the condition, the quantity, the price, the period should be settled between the parties. And this is the law of dealing or the law of contract, which you call in the modern legal word. You know, this is the law of contract that is there. The principle of writing and retaining the document did not exist before the advent of Islam. People would do an oral thing, but they wouldn't write. And this first was highlighted by Quran 1437 years ago, that when you have a debt-based transaction, you must put it into writing. So the written document must be prepared while the transaction is being concluded on deferred payment, so that if there is a dispute later on, this written document can be referred to. And it is extremely important that when you are writing such a transaction, there are certain prerequisites that needs to be there. Whenever there is a deferred payment, which means that the payment will be made after some time, then the due date of the payment must be specified and determined. It's not really permissible to say that I will pay whenever I have money. Then this is a void contract. Or I will pay in August, because you need to be specific to say August 2016, 1st of August, that is there. So the time limit should not have any ambiguity. So you can't say that I will pay you at the time of harvest, or when I harvest my wheat or my rice. You cannot do that. You have to give a specific time, because harvest may vary according to various weather conditions. What this ayat also says is that the scribe, the one who is writing the contract, he must not be prejudiced in favor of one of the parties. He must be neutral, and he must be impartial, because so that there is no dispute. Now let's just look at the next part of this ayat is the attention is on the scribe. The fact that he has been given the ability to write, and this ability he must use it to show his gratefulness that Allah has given him the ability to write. So the next part of this ayat, وَلْيُمْلِلِ الَّذِي عَلَيْهِ الْحَقُّ وَلْيَتَّقِ اللَّهَ رَبَّهُ وَلَا يَبْخَسْ مِنْهُ شَيْئًا, and let him who owes the debt dictate, but let him fear his Rabb and not diminish anything from it. So when you are writing this document, the debt document, the contract of debt, the one who is taking the debt, he is the one who dictates the terms. Now you can see the wisdom behind that, because the weaker party is the one who is taking the debt. The stronger party who is the one who is giving the debt, he can actually dictate. So Quran says, let him who owes the debt, let him, the one who is taking the debt, dictate, but let him fear his Rabb and not diminish anything from it, that he must also be fair. So therefore it's not the creditor who is writing, it's the debtor who is he's dictating the terms of the contract, because the entire liability of the transaction lies on the debtor, and therefore he should fully understand the nature and the extent of the liabilities, what debt he is taking, when he has to pay back, etc., etc. All these things have to be there. Moreover, the document remains in the custody of the creditor. So it is written by the debtor, the terms are dictated by the debtor to the scribe, but the original document is with the creditor, because he is the one now who has lent the money over here. So the undertaking is left to the weaker party, which is the one who's taking it and one who's contracting the debt. Now, if a person has made a purchase on credit, that means I buy something now and I say I'm going to make you a payment later on in 2 months or 6 months, then he should be the one who should dictate this document in English. So therefore again, also emphasizing that also fear Allah, because one of the, every law has a flaw, as they say. Every law has a loophole. So therefore, everywhere, even if you have the best lawyers, it will all sometimes go into dispute. So you must have fear of Allah, and that's what is being reminded over here. فَإِنْ كَانَ الَّذِي عَلَيْهِ الْحَقَّ سَفِيهًا أَوْ ضَعِيفًا أَوْ لَا يَسْتَطِيعُ أَنْ يُمْلِلَ هُوَ فَلْيُمْلِلْ وَلِيُّهُ بِالْعَدْلِ. But if he who owes the debt is unsound in understanding or weak and unable to dictate, let his guardians dictate with justice. So if the debtor is of unsound mind, which means that he has some kind of a disability, or he's a minor, or because of old age or because of illness, then he must appoint a guardian who must dictate the terms of the contract. Now, it sometimes also happens that a person who is taking the debt, he speaks a different language. So suppose you have a transaction in the person who's taking a debt, he only speaks Arabic, and you are the one, you speak only Urdu. So therefore, you don't understand each other's language. So he must appoint a guardian. The one who's taking the debt must appoint a guardian who speaks the language, so that there is no ambiguity in what is being required. So you see how, right up to the very end, Islam goes on in order to ensure that there are no disputes that are arising. So if there is a language barrier that is there, then he does not have the ability to dictate the document. So in such a case, his wali or his guardian should dictate the written document, and that is there. Now, so we have now covered two things. One is that every contract must be written down. Number two, that there must be a scribe, and that if the one who is taking over the debt, he cannot understand the terms of the contract, then he must appoint a guardian who has a complete understanding, and he must dictate it to the scribe. Now, the third part of this ayah is about appointing witnesses. So we'll go over this. وَاسْتَشْهِدُوا شَهِيدَيْنِ مِنْ رِجَالِكُمْ فَإِنْ لَمْ يَكُونُوا رَجُلَيْنِ فَرَجُلٌ وَامْرَأَتَانِ مِمَّا تَرْضَوْنَ مِنَ الشُّهَدَاءِ أَنْ تَضِلَّ إِحْدَاهُمَا فَتُذَكِّرَ إِحْدَاهُمَا الْأُخْرَى. And call to witnesses out of your own men. But if there are not two men, then one man and two women from amongst those whom you choose to be witness, so that if one woman forgets, the other woman reminds her. So this is what this ayat is really saying, is that simply writing a contract down is not enough. Yes, you have written the contract, but then this is not a conclusive proof in the sight of Islamic Sharia, unless that there is an oral evidence by the witness to this agreement, and no decision can be taken simply based on a contract. So therefore it says, call in your witness, two men, and if there are not two men, then one man and two women. Now this has become like huge controversy in the world, why it should be two women and for every one man there should be two men. Remember, this is basically for financial transactions only. We are not talking of every transaction where one woman witness is not enough. In case of the murder of Usman Raziyallahu Anhu, the only witness that was present at that time was Naila, his wife. She was one single witness, and her witness was accepted as far as recognizing the murderers were concerned. So this is not like for everything that there has to be two women who have to witness. It's only for financial transaction. And also the fact that to be a witness to a transaction is not a money-making business. I mean, this is a serious responsibility. And that's the reason even two men are put over here. Men can also say, why two men? Does not Allah trust me? Why does he want that as a witness, I need one more man to be a witness with me? Doesn't Allah trust me? Of course Allah trusts me, but the fact is that there is a huge responsibility. So therefore, it needs two people to be there so that there are no differences. And if someone forgets, and as I say, so one of you forgets, the other woman can remind her. So again, we shouldn't really go into this dispute of men are better or women are better. Both have a role to play. They are two separate creations of Allah. And here I would say Allah has reduced the responsibility on women by actually making that men should be there in a financial transaction, two of them, or against one of them, two women. Allah has reduced their responsibility, because in many times, and especially in many areas, women are not that kind of business oriented, so they are not really familiar with the terms of agreement, and so therefore there will always be exceptions. Some women are financially and business wise very clever, more clever than men, but these are exceptions. It's not a general rule. Generally it's the men that dominate the business side. So common courts today also follow this practice, that when they take a decision, they take a decision based on the verbal evidence, which is the proof of the document that's there, but also they take witnesses, and those witnesses are also called. Now, for being appointed as a witness, there are certain conditions that must be met. First and foremost is that they must be trustworthy and they must be just. Their word should be relied upon. They shouldn't be sinners and liars, and they should be among Muslims. They should be adult with unimpaired reasoning. They should be free men, not slaves, and they should be of good character. And if disputes are to be decided based on the testimony of the witness, and not on the strength of the written document, the role of a witness is extremely important. So therefore this is being put over here. Like I said, this is only for business transaction, because women do not generally take part in business, so therefore sometimes they are unable to understand the transaction. So two women are required, so that if one forgets the testimony, the other one can remind her of that. Islam is way ahead of other religions. In fact, if you look at Judaism, in Jewish court, the testimony of women is inadmissible. They do not permit women to come in as a witness at all. In Islam, only in financial transaction you have two women and one man, or it's there, but for murder and for other things and other testimonies that are there for the parenthood of a child, it's only women whose witness is really accepted. So to give evidence is not a matter of right. In fact, it's really an obligation. And the law has imposed upon people that they must do witness. And witness may also be subject to cross-examination, and so they are not permitted to refuse to answer the question when the court asks them, and they can actually be punished for giving a false evidence. If it is found that there is a witness and that he falsified his, falsified giving a false evidence, then he can be punished by the court also. So like I said, Islam is actually favoring women by really lightening their burden of bearing witness for monetary transaction, and I'm sure that there should be no real dispute on that. وَلَا يَابَ شُهَدَاءُ إِذَا مَا دَعُوا, and the witness should not refuse when they are called upon. So Quran actually directs people that they should not refuse to bear witness when it is required of them, since evidence is the way to really find out the truth, and so therefore this is the only way to resolve the disputes. Even if it is inconvenient for the witness in giving evidence, it should be tolerated. If you are called upon a witness, you must consider this to be a duty, because the entire dispute can be settled and decided based on the testimony of the witness. Therefore, if a person refuses to be a witness, then the entire judicial system will collapse, and no one will be in a position to seek relief through the court in a case of dispute. So Quran had made it obligatory for a person to become a witness. If a person refuses to become a witness, then while he has a knowledge of some event, then he has actually committed a sin. It is a sin to actually refuse to be a witness. In our case, we have seen, many times people witness a murder, they witness many things, and when the court calls them, they say, we didn't see anything. It's a common thing. I think if you remember this recent case which happened in Lahore, the son of Kanju, which is who murdered in an open, in a public place, and all the witnesses that were there, in the end they withdrew out, and they said, we didn't see it. So from an Islamic point of view, actually all these witnesses should have been punished, because this was well recorded, well documented, even there are video clips of it and everything. So therefore they can be punished because of the fact that knowingly they didn't give a witness. وَلَا تَسَمُوا أَن تَكْتُبُوا صَغِيرًا أَوْ كَبِيرًا إِلَىٰ أَجَلِهِ, and do not neglect writing it, be it small or large, with the time when it is due. So small or large again is a relative term. Something that is large for me may be very small for someone else. It may be very small for, so it doesn't matter if the debt is small or large, it must be written down in order to avoid any future misunderstanding. ذَلِكُمْ أَقْسَطُ عِنْدَ اللَّهِ وَأَقْوَمُ لِلشَّهَادَةِ وَأَدْنَى أَلَّا تَرْتَابُوا, and this is more equitable near Allah and assures greater accuracy in testimony and the best way to avoid doubt, because Shaitan wants to create doubt between different people, between Muslims, hence he will always try and create them. So therefore it is best that we have a good written document and good witnesses on that. إِلَّا أَن تَكُونُوا تِجَارَةً حَاضِرَةً تُدِيرُونَهَا بَيْنَكُمْ فَلَيْسَ عَلَيْكُمْ جُنَاحٌ أَلَّا تَكْتُبُوهَا وَأَشْهِدُوا إِذَا تَبَايَعْتُمْ, and except when it is on a spot trade which you give and take amongst yourself from hand to hand, then there is no blame on you in not writing, and have witness when you barter with one another. So this is an exception that's being provided over here, that if you go to a shop and you buy bread and you pay the money, obviously you're not expected to write it down. It would be very cumbersome. So you see, nature, it's a spot transaction, which means you buy the goods there and you pay the money there, which is what you call a spot transaction. In that case, you just buy and take, you don't have to write. But it says if you're doing a barter transaction, that you give something and then you buy something, some other commodity, it's always good to have some witnesses to that. It's a preferable thing, it's not a mandatory thing, it's a preferable thing that is being put over here. وَلَا يُضَارَّ كَاتِبٌ وَلَا شَهِيدٌ, and let no harm be done to the scribe or to the witness. وَإِن تَفْعَلُوا فَإِنَّهُ فُسُوقٌ بِكُمْ وَاتَّقُوا اللَّهَ وَيُعَلِّمُكُمُ اللَّهُ وَاللَّهُ بِكُلِّ شَيْءٍ عَلِيمٌ, and let no harm be done to the scribe or the witness. If you do it, then surely it is a sin with you, and fear Allah, and Allah teaches you, and Allah knows all that, and Allah knows all the things. So therefore, causing any harm to the one who is writing or the one who is witnessing is prohibited. And this is in order to protect one's rights and benefit, one should not disturb the rights and benefits of the other. So the scribe, a scribe who is writing down, actually he can demand a wage for writing that contract. He is permitted to demand a wage, and the witness who claims can also claim that his expenses be met. So if you call a witness from one city to the other to give an evidence, then from a Sharia point of view, you have to actually, depending upon the status of the witness, to give him the conveyance that is deemed for his position. He is also entitled for payment of the expenses that he will incur while he is there. For giving the witness. Not paying the due is like harming them, and this is this is not permissible. Like I said earlier, in Islamic system of justice, the witness has to appear in the court. At the same time, the right of witness are also protected, so that the people are not made to stay away from testifying. Obviously, this has the world has bypassed many of these good injunctions that Islam has taught us, because we just read them in Quran, but unfortunately we don't put them into practice in our own lives. A lot of time people don't even know that there is an ayat, which is ayat al-dain in Quran, which talks about how important it is to write a debt and how important it is to have the right witnesses on that. So these principles have almost like gone away, because we've gone away from Quran. How many of us really understood, read the Quran page to page, not just in Arabic but also in English, and try to understand it? Unless we understand, obviously, how can this become a book of guidance for us? It is maybe a book of sawab for us because we read it in Arabic, but certainly for it to become a book of guidance, we must have a good understanding of what Quran is saying, and that is only if you can understand what is written. And in this age of today, where everything is available, all the translations, everything, dictionaries, even word meanings are available, there is no excuse for us not to know. A lot of people say, oh, I didn't know this was part of Quran. Well, that's your problem. You need to know because you read everything else. Why not this book that is there? So, and even today in our general societies, we find that no one wants to become a witness. Honestly, if you ask me, if somebody says can you be a witness, I'll try and avoid as much as possible. And the reason for this is because to be a witness means huge trouble for yourself. What the police is going to call you in the thana day after day, make you sit for hours together. Then the court will start to treat you like a criminal, and they'll keep, delaying the proceedings. You go once and then you go again, and the dates keep changing, and you have to leave your job to do this. And it's really, no decent person would like to appear in the court. It's more like a punishment for a crime that you have not done. So you say, why do I want to be a witness to this? Because I've not done the crime, but just to be a witness is such a problem. So that's the reason why people avoid being a witness, and that's the reason why we have such a problem that we cannot actually get justice from the system. وَإِن كُنْتُمْ عَلَى سَفَرٍ وَلَمْ تَجِدُوا كَاتِبًا فَرِحَانٌ مَقْبُوضًا فَإِنْ أَمِنَ بَعْضُكُمْ بعضا فليؤدي الذي اؤتمن أمانته وليتق الله ربه ولا تكتبوا الشهادة ومن يكتمها فإنه آثم قلبه والله بما تعملون عليم. And if you are on a journey and you do not find a scribe, then pledge with possession will suffice. But if one of you trusts another, he who is trusted should deliver his trust and let him fear his Rabb, and do not conceal evidence, for whoever conceals his heart is surely sinful, and Allah knows what you do. So this verse is actually dealing with loans against security, rehan. So this ayat that comes over here, in kuntum ala safari walam tajidu qatil farihanum maqbuda. So you have to do a rehan, which means that you can pledge something as a security, giving the fundamental principles which is used by lots of banks today, that you can take rehan for a loan that is being extended by the bank. So this is justified from Quran, that for a debt that you are acquiring, you can give some property as a collateral. So therefore this loan is a kind of a security or a deposit which is delivered to the creditor. It is to be returned back when the loan is fully repaid. And this is a transaction which you call, you do a mortgage of a property, or you do a mortgage of a land, or something like that. So